All right, let's get started. Good afternoon, everybody, and welcome. My name's Verna Williams. I'm the Dean of the College of Law, and it's my pleasure to welcome you here today to today's Victor Schwartz Torts Lecture. That is a tongue twister. My job afternoon is to give you a little bit of background about the talk and then to introduce our guest speaker. Victor Schwartz is the benefactor of this event, and he's a wonderful friend of the College of Law and a luminary in the legal field. Victor served as a professor at the College of Law, then as acting dean, and now as a member of our Board of Visitors. As students, you may know him as the a co-author of the most widely used casebook on torts in the U.S., Prosser, Wade, and Schwartz, Cases and Materials on Torts. Legal scholars know Victor as the author of more than 150 law review articles that address almost every imaginable important aspect of tort law. And the sad news for us today is that Victor's unable to join us. It's hugely disappointing to me because in addition to being a remarkable scholar, Victor does amazing impressions of political figures. And he's simply a delight to be around. We are truly lucky to call him a friend of the College of Law. Today, we are honored to welcome our Victor Schwartz Torts Lecturer, Dean Ward Farnsworth. He's here to discuss his role as a reporter of the American Law Institute Third Restatement on Torts. Ward has been Dean of the University of Texas School of Law since 2012, and he holds the John Jeffers Research Chair in Law. Ward has described himself as having too many interests for his own good. He has written extensively in a wide array of topics, including rhetoric, philosophy, and chess. His most recent book is The Practicing Stoic, a philosophical user's manual. The Washington Post has praised it as, quote, not just a book to read, it's a book to return to, a book that will provide perspective and consolation at times of heartbreak or calamity. He's also published articles in such publications as Columbia Law Review, University of Chicago Law Review, and the Michigan Law Review. Before entering the academy, Ward clerked for former U.S. Supreme Court Justice Kennedy and for Richard Posner on the Seventh Circuit Court of Appeals. And he has worked as a legal advisor to the Iran-United States Claims Tribunal in The Hague. He's a graduate of Wesleyan University and the University of Chicago Law School. And so without further ado, please join me in welcoming Dean Ward Farnsworth to the College of Law.
Thank you, Dean Williams. Thanks to all of you for being here today. It's my first time at the College of Law. Cincinnati has a special place in my heart. I don't know how many of you were living here back then, but when I was a kid, all I cared about was the Big Red Machine. I was in Chicago, but the Chicago Cubs were a terrible baseball team, so I adopted the Reds, and I would listen to games on my little AM radio, and at night they would waft through. There was Marty Brennaman. I think maybe you can still listen to Marty Brennaman. And I had pictures on my wall of Johnny Bench and George Foster and all these players. I could go through them very easily. And I wrote to Pete Rose, and I asked him for his autograph. And every day I'd come home from school, I was 8 years old, I'd come home from school and wait for it to come in the mail, and it came, and it was a photocopy, and I was reduced to tears. But I got over it, became a practicing Stoic, as the dean mentioned, and the rest is history. In any event, I'm very proud to be here with you, especially to deliver a lecture endowed by my good friend and your great friend, Victor Schwartz. Most of you know Victor, I imagine. If you're close enough to the school to be here, you're close enough to know Victor. But I'm sure that those of you who work in his field have your agreements, maybe in your disagreements with Victor. But one thing I hope you all know and can appreciate is that Victor's as dear a friend as this school could hope to have. I've heard from him over the years so many wonderful things about your school, which has a great reputation apart from anything Victor might say, I'll add, but I've heard a great deal from Victor. He sings your praises and speaks of the school with enormous pride. Every law school should have friends as faithful and accomplished as Victor Schwartz. You're also fortunate to have a great dean, interim or otherwise, in Verna Williams, and I'm very grateful for your nice introduction and for the invitation to be here. So I want to talk to you a little bit about my experience as reporter for the for what's formally called Restatement Third, torts, liability for economic harm, although people refer to it in lots of other ways. I thought I would describe a little bit about how a restatement gets created, and then talk about a thing or two that I've learned from the process of working on it. So I was named reporter. It's kind of a funny name. I'm reporting. What am I reporting on? Your function when you're a reporter is more like a researcher and author, or so it seems at first. So my project involves liability for torts that cause no personal injury or property damage, just pure financial loss. For example, claims of fraud, commercial torts that involve interference with contract will be other examples. Even some negligence cases, professional malpractice by a lawyer or accountant would cause pure financial loss, would be tortious, as well as probably a breach of contract. It would be within my bailiwick. And so your first task when you're a reporter is to pick one of these topics and get down into every detail there is in the court cases about it. You read what's been said by every court that's handled every little issue. You take copious notes. You find where they agree, where they don't agree, what they haven't settled. And then you start reading commentary. You read treatises. You read law review articles, all the scholarship you can find. I did all this, and then sometimes I would also consult with people in the profession. So, for example, one of the difficult issues when it comes to liability in negligence for pure economic loss is how you handle a case when you have let's say a city, the city of Cincinnati, decides to build something, and they hire an architect to design it, and they put the architect's plans out for bid by contractors. The contractors bid for the right to do the job. One of them wins. The lucky contractor wins, but they're not so lucky after all because it turns out the plans are defective. They start to build the building and they discover there's something wrong and the job is more expensive than they thought. The question becomes, who can they sue? Can they sue the party that drew the plans in tort? That party was negligent, let us imagine, right? You are the builder. You'd like to sue the architect who made plans that you relied on, but you had no contract with them. You both had contracts with the city. And the question is, can you bring a claim? Well, there's a division of authority on this question. Reading the cases is not going to settle it for you or for me as reporter because the cases go different directions. One thing I did was call lawyers and interview them in various states that had different rules to ask, how does this rule work? You're in a state where there's no liability. How do you handle that? You're in a state where there is liability. How do you handle that? In high-stakes cases, it turns out to make very little difference because the lawyers are happy to contract their way around whatever the tort rule is. Sophisticated lawyers just want clarity. They're not too fussy about the rule. In small stakes cases, it makes more of a difference because the parties are less sophisticated, less likely to have legal counsel, and so forth. So in that case, the ALI's, the draft that's been approved, recognizes tort liability. But my point now is simply to describe for you some of the sources of guidance that as a reporter I tried to draw on. It takes a very long time to read all the case law on every little issue that might arise, even with respect to cases like the one I just described. When the process is done, however, there's a considerable feeling of satisfaction that having read what the courts say and what the commentators say and talked to lawyers, you finally got it all right. But the satisfaction is very short-lived because you're not done. You take this draft you've written and it circulates to what's called the members consultative group at the ALI, which means members who have asked to be apprised of developments in the field that you're writing about. So you circulate the draft to them and you go meet with them, probably in Philadelphia where the ALI headquarters exists. You meet in a room about this size, but the room is flat, and the members file in. Some of them have sent notes in advance pointing out problems in the draft. Others you spend all day with, from 9 or 10 in the morning till 5 in the afternoon, going page by page through your draft and having darts thrown at it, having members raise their hands and say, I don't like what you said in this illustration. I think you have it wrong here. I don't understand why you said that. And by the end of the day, you're really tired because this draft you thought was so good has been revealed to have lots and lots of holes in it. But you're also grateful because when you fill the holes, you'll have a better draft. And then you feel a considerable sense of accomplishment. But it's short-lived because you're still not done. Because now you have to deal with your advisors to the project. They aren't the members consultative group. They're advisors appointed by the director of the ALI who have expertise in your area. Academics, lawyers, judges, who have a lot of experience, in my case, with torts that cause economic loss. They all assemble, usually the next day, in the same room for another 8 hours. And all day long they raise their hands and say, Ward, what were you thinking when you wrote that? And they'll tear it apart, and your heart sinks because you were so pleased with your draft. But it's another day of watching your work be torn apart so that it may be built up again into stronger form. At least by the time that's done, you have a considerable and better earned feeling of accomplishment. And yet even this is short-lived because you go home and you take into account all of these comments and you spend months rewriting. I spent a couple of months, mostly on weekends. I'm a dean too. So at nights and weekends, I'm spending my time taking all these comments that I took notes on at the meeting and that were sent in to me, dozens and dozens, maybe hundreds, depending on what we're talking about, and researching them to see what merit they may have had and fixing the infelicities in the drafts and making clear that which was unclear and trying to make right that which was wrong or not sufficiently considered. And at least then, I've got something I'm pleased with. But you know, my satisfaction is short-lived because I haven't yet dealt with the ALI Council. Once I finish that draft, the draft is circulated to the ALI Council. This isn't the members group, and it's not the advisors. It's a general group of very distinguished lawyers, academics, and judges who oversee all the ALI's projects. And they receive a draft, and then I meet with them, probably in New York, maybe in Philadelphia, in a room not unlike this. And they spend another day, or maybe half a day, doing all that I've just described, going back to the beginning and saying, I don't understand this part. I don't like that part. I have some experience with this area. I don't think you've got it right. I'm very worried about this illustration. It doesn't seem correct to me. And you spend all your time on this. And again, your heart sinks. But you're used to it by now. You're used to the feeling of the sinking heart because you want it to be better. And so if you're going to be an ALI reporter, you need a thick skin, a steady diet of the stoicism that I write about in my spare time, because your work receives a lot of criticism, in this case from some of the greatest minds in the legal profession, very distinguished people. And they're not always right, but very often they are. And you have to get used to the idea that when you're trying to write something like this, you're going to be wrong a great deal. I'll come back to that. In any event, at last the council's done with it, and you go back and you fix it up. And now you're done. But not really. Because the draft still now has to be circulated to the members at large. And then you meet with the ALI membership. It's just anybody in the ALI, hundreds of people at a ballroom. Usually it's at the Ritz-Carlton in Washington, D.C. in May. And you go to a table there in a room that's not like this room this time. This time the room is maybe 6 times as large, full of people who have all read the draft. Well, some of them haven't read it, but many of them have. And they line up at microphones this time. They don't raise it. They line up, microphone 1, microphone 2. And they stand there and they'll say, George Saunders, Altoona, Pennsylvania. I don't like illustration 18 on page 40. What seems to be the problem? And there is some problem. And you get people lining up for hours to point out the problems in your draft. You thought for sure you'd caught everything. This thing's now been vetted by a couple hundred people. And you've taken into account hundreds of comments. You can't believe there could still be glitches, problems, or sources of major objection. But there are. And so you go back and you fix it all up. And at this point, I won't continue the running gag about it never being done, but it really isn't quite done because I'm now at a moment, as I stand before you, when my drafts have all been approved by the membership, but I'm still circulating last changes in response to that meeting to some of my more faithful and better advised advisors, just to make sure they don't have any issue with something I've tried to fix in response to a comment from the floor. So after all these rounds of review, you finally have a restatement. And the restatements that are created after this fashion are, as you all know, highly influential. Courts are a lot more interested in this document that I've worked on as a reporter than they are in anything I've ever written as a scholar or anything I'm ever going to write as a scholar. Much more interested. And my ego has to adjust to this. And the question is why. But there are, of course, very good reasons why. First, and these are a couple of the lessons that I wanted to talk about. So an American Law Institute restatement properly done is an exercise in harnessing collective wisdom, as I think is evident from the tale I've told. And that's really the reason why they receive the weight that I do. Collective wisdom is a very particular thing, and it comes in many forms. So, for example, the collective wisdom of the courts is something other courts are very interested in. When they read a restatement, they know they're not reading, at least not primarily, what Ward Farnsworth thinks about anything, not even what the American Law Institute's members think about anything. They're reading first and foremost what the courts have thought about something when the restatement is faithfully done. It captures not what any one judge has said or what any courts have said, but what the consensus of courts have come to. And I think it's fair to say that most judges and many commentators have more respect for opinions reached by many judges under those circumstances than they have for what any one judge or one academic, certainly, has thought about anything, let alone a great many academics. Because when judges make decisions, of course, they're operating in a common law system where there are high stakes. They've got matters in front of them that turn on their decision making. And that's why we have a system of stare decisis. Put together enough of those decisions, and you have something that I think most judges regard as being more weighty than what any one person, no matter how wise or intelligent or learned, might think about anything. Decisions that have stood the test of time, that have been reached by more than one person on more than one occasion, and that have reflected the considered judgment of courts on a wide range of fact patterns. You've got collective wisdom of other kinds as well, however. You've got the collective wisdom of those commentators who the reporter went off and diligently read when drafting the restatement, including academics and articles and treatises, lawyers who I've talked to. Then you've got the collective wisdom of the advisors and the members in those rooms that I've talked about where darts are thrown at my work. They, too, I think, are wiser than any one person. The general view you come to when you do this work is that everyone is wiser than anyone. In other words, when you've got a large group of people who are duly informed, talented, intelligent, putting their heads together, the result you're likely to get is going to be a higher level of wisdom than what any one of them would have thought. I don't care who they are. And that's very true, at least, of your humble reporter. These jobs are very humbling because after you've taken your work, which you're very satisfied with, I describe the feeling of satisfaction, but I think we've all had it. You work for a long time on a brief or a memo. It's very easy to get very pleased with yourself, especially after you've caught lots of your own mistakes and then gone to work on it again, and you think, boy, I've really got him this time. Isn't this fine, this thing I've done? And that luxury of feeling that way, I think, really only belongs to people who do not hold up their work for public criticism over and over again. Because no matter how good a job you think you've done, you put enough smart people in a room who know what they're talking about, and they'll find lots of things you could have done better. And most of us, at least, perhaps I should speak for myself, do not have that experience so often. When you're a scholar, you write articles, and you generally think you've done a nice job by the time you're finished. If you don't think that, you stay at work until you do. You may or may not get a lot of criticism. You might present the work at a conference and get some comments, and they're helpful because you realize you've missed some things. If you're lucky, people read your work and criticize it in print. Sometimes they do, sometimes they don't. But to go to a couple of rooms of dozens of people from all parts of the legal profession, hold it up, and just invite them to spend 8 hours just taking it apart and pointing out everything that could have been better, boy, that takes you down a peg. But it does raise the work up in the end. It does, in general, though, give me a much reduced view of my own powers of analysis or powers of anything else, and a much more accurate view, I think. It's a lot harder to be smug or very satisfied with anything you've done after you've heard it criticized so many times. But the good news is that once you're finished, you can be proud in a different way. Not proud, gee, look at the clever thing I've done, but proud, gee, look at all the wisdom I've managed to assemble in this place, wisdom that doesn't belong to me. And that's why you're called a reporter in the end. Because by the time this process is done, you really don't feel like an author. You feel like somebody who did a constructive draft, and then somebody who took into account an enormous number of opinions by others, and hopefully was responsible in weaving them together into something that's basically a group effort. Not a committee effort. We've all read ghastly writings by committees. Nobody likes those. That's the nice thing, I think, about the balance the ALI strikes. It's written by one person. It has a uniform voice, I hope. I stand behind the whole thing. But the substance of it, as well as many of the detailed drafting decisions, reflect so much work by so many people that it's really much more than the work of any one person, and I don't feel like it's mine. And when you read the restatement, you won't see my name very prominently. You'll see it mentioned that I was the reporter. I think that's right. What you see there is the work of many courts, many academics, many lawyers, many judges who've all contributed and worked on this thing. I don't really feel a pride of authorship. I feel some pride of being an overseer or supervisor of the construction of this thing. The next issue that I think is worth touching on from a learning standpoint is how much should one care about winning or being right in a discussion of high-stakes legal issues. So I've now spent a lot of time in these rooms full of people who have strong opinions about the issues that are in the restatement. I, too, of course, form strong opinions about these things. When you spend a long time reading about them and writing about them, you get invested. And, of course, there's a potential for some pretty heated debate. And at the ALI, you occasionally get pretty heated debates about how to resolve one question of tort law or another, or questions outside of tort law. I suppose I was lucky that my area of tort law was considered relatively dry. There were some contentious issues within it about how we define fraud or interference with contract, but perhaps not as contentious as some of the issues that arose, for example, in the products liability restatement. In any event, some of the issues were contentious enough. And in an environment like that, it really gives you a chance to think about how to handle dissent and how to handle disagreement between others and between others and you and you and the courts. And I think the lesson, again, is not very different from the lesson I was talking about earlier. It really has to do with humility and with deciding how much, as I say, to care about whether you're correct or not. If you're involved in an ALI project, but I think it's true whether you're involved in just about anything, there's a right amount to care. You want to care very deeply about being right. And that needs to be very important to you and getting the project right. But when you're in a dispute, the question is, just how hard are you going to fight, and how much of a calamity is it for you if you admit you're wrong, or if you decide that even if you're not ready to admit you're wrong, you're ready to defer, you're ready to lose. That's something we all go through in arguments we have, debates with colleagues about policy around the law school, debates with colleagues perhaps about what to do how to handle a case, what position to take. In student organizations, I think it's a very rare thing that we're in a group enterprise where we don't disagree with each other. And the question then becomes, how do you conduct yourself? It's a very important lesson for our culture in general. Perhaps we can agree, because I don't think the art of civil disagreement is being carried out at a very high level right now in our national government or perhaps elsewhere. So what do we find at the ALI? I think the American Law Institute is a successful enterprise in the American legal firmament, mostly because there's a culture there of civil disagreement and willingness to be wrong and willingness to lose. You certainly get used to being wrong often enough when you're a reporter, because it's pointed out that you're wrong often enough, and you go back and realize, I guess I was. But this idea of optimality, I think, is worth pursuing a little bit, because I think most people feel most of the time that when they're sure they're right, the amount they should care is almost absolute. You just fight until you can't win. And I don't think that's quite right. You know, there are a lot of things in life that are best pursued not to a maximal degree, but to an optimal degree. Due care is probably like that in torts. And, of course, there are economists. I think George Stigler said that if you've never missed a flight, you're spending too much time at airports. And if you never get turned down when you ask somebody for a date, you're aiming too low. You should be asking other people for dates. But it's okay. The point is, it's okay to lose, and you probably ought to lose sometimes, or you're not playing the game correctly. And I think that's true in these settings. And the reason goes back partly to the collective wisdom I mentioned, but I think it goes back to a healthy understanding that we're all wrong a lot. I think it's very valuable for lawyers to remember that you're wrong pretty often. And if you don't realize that, it's probably because your life or your professional existence is structured in a way that does not drive it home very often. I would advise you to try being a reporter for the ALI for a little while, or maybe become a dean. These are very humbling experiences, and they give you lots of chances to receive criticism and to realize that you've made mistakes. And after a while, you realize, we all make mistakes. And even apart from making mistakes, we're just incorrect. And sometimes it takes a while to see that. Not everybody's professional life is set up to drive this home. It's sort of, those of you who've taken negotiation courses or taught negotiation will know this. When you negotiate in real life, you always feel you've done a good job. Because when you're done with your negotiation, you don't buy or sell anything or finish whatever you're doing until you're satisfied. If you're satisfied, you must have done well. You don't know how well you could have done if you'd done a better job. Life doesn't show you that. Negotiation classes show you that because they put on the blackboard a listing of everybody's results, and you realize, my God, I was terrible. And so not every life experience gives you the luxury of seeing how wrong you can be or how defective your judgment can be. But the experience I had does that, and I think it's worth reflecting on. I will comment a little further on this. In my teaching, I spend a lot of time with students trying to help them understand their probability of being incorrect. I try to stress to them, I don't care how often you're wrong. That's okay. It's okay to be wrong a lot. Get used to it. We all are. The question is, are you wrong about how often you're wrong? That's a much more serious problem. Making a lot of mistakes is not a big problem if you know how often you make them, and you know how to address them, you know how to address the risk, you know how to get them vetted, you know how to fix it. It's probably healthy, because you probably do make a lot of mistakes. But if you make mistakes and you don't know it, if you're wrong about how often you're wrong, that's a much more serious problem, because it prevents you from fixing what needs to be fixed. And unfortunately, that problem is pervasive. So in the literature of cognitive psychology, which I'm sure some of you have studied, this problem has the technical name of calibration, which how well calibrated are your judgments, the psychologists ask. And what they mean is, when you predict how likely you are to be right, how likely are you in fact? How accurate are you in assessing the probability that your judgment about anything is an accurate judgment? Most people are not very good at this. They feel they're pretty good at it, but they're not. But how do you show them this? Well, here's how I show it to them. I give my students surveys or questionnaires with lots of questions on them that I know some of them will be right about and some of them will be wrong about. I say to them, true or false, the capital of Kentucky is Lexington. That always gets some takers. Why, for that matter, the capital of Ohio is Columbus. That always gets interesting responses. In any event, you can ask lots of questions about this, about whether more people die in a given year from drownings or from fires, about whether Artemis was the Greek deity for this or for that. All these questions doesn't really matter, because I don't care whether they know the answer to any of these things. But I want to see how likely they are to be able to guess not what the answer is, but whether they're right. So they answer all these questions, and then I say, state the odds that you're correct about this. You can give a percentage. I'm 70% sure about this. I'm 60% sure. I'm 50-50 on this. I'm 99% sure. That's all I really care about. Of course, they're law students. They think I care whether they know what city is the capital of what state. But I assure them, I don't care. What I'm interested in is, are you correct about which city is the capital of where, but are you correct about how likely you are to be correct? So if they say that Toronto is the capital of Canada, I don't care. But if they say I'm 99% sure it is, then we have a problem. Then we have a different kind of problem. If they say I think it is, but I'm only 50-50 sure, I say no problem. That's just your way of saying you don't know. Nothing wrong with saying you don't know. That's good for you as a lawyer. Admit you don't know. It's the lawyers who think they know and they don't. That's the problem. And that's most people most of the time. Because what you discover when you do these surveys is there's nobody who underestimates their probability of being right. Everybody, and I mean everybody, overstates the probability that they're right about the things they think they know. And the reason I give them lots of these questions is because it's only by doing lots of them that you can see how bad you are at this. I mean, if you say, I'm 90% sure of something and you're wrong, say, oh, well, I told you I might be wrong. Sure, you said you might be wrong 10% of the time. If I give you 100 questions and you say you're 90% sure about a lot of them and you're wrong about half of those, now you know you have a problem, because you're only right half the time about things you thought you should be right 9 times out of 10. That's a little extreme. It's more likely that when you feel 90% right, you're probably right about 2/3 of the time, it turns out. This is what all the research shows, and it's what happens when you replicate this, and it's probably what would happen if I did this to you, because it's what almost everybody does. That feeling of certitude is not a good test of actual truth, but it's so convincing, because when you feel you know something, when you feel you're right, it's very hard to believe that you're not as likely to be right as you think, especially when you are likely to be right. If you're 60% likely to be right, you're probably right. But you're not 90% likely to be right, and there is a difference, especially when you're giving advice to a client about what's going to happen if they go to court or about anything else, or when you're in an ALI meeting, to bring the issue back to that. Now, of course, in an ALI meeting or in any legal setting, you're not talking about factual judgments like what city is the capital of what state, or what the more common cause of death is. Those are fact questions. And those aren't really the issues people get heated about. They get heated about judgments, about what the right policy is, about what's moral, what's right or wrong. So in those settings, can we take more heart and say, well, at least in those areas, you don't have to worry about being wrong because it's just whatever you think. But I don't think that's true. I think you have to be more worried about being wrong because there's no way to verify or falsify or whatever you may think about these things. Now, I'll admit that whether there's a right or a wrong answer to a question of ethics is a very ancient question that I don't propose to try to solve here, and I admit it's very difficult. But I think you can be right or wrong in a narrower sense. You can be right or wrong about whether, for example, you would say the same thing if the tables were turned. You know, I'll raise a sensitive issue. Let's imagine you hold a strong opinion about whether Brett Kavanaugh should have been confirmed to the Supreme Court. Because let's face it, most people do or did hold a pretty strong opinion about that. I would say that it's hard. I wouldn't propose to say there's a right or wrong answer to that question in the same way there's a right or wrong answer to factual questions about which city's the capital of which state. But there might be true or false answers to questions like this. Would you hold the same opinion about that if you liked what you thought he was going to do as a justice? So if somebody supports Brett Kavanaugh, despite the things said about him in the hearings by Christine Ford, one question I'd ask is, do you think you'd feel the same way if you didn't think he was going to make decisions you'd like? So if somebody says, I don't believe her, I believe him. I think it's a question, yeah, but would you say that if he were liberal? And you were rooting for him in other ways? Because people fool themselves about this, and you can turn it around the same way. People say, I'm opposed to him. I think that it's very important if he did this thing, even if it was when he was in high school. And you can ask, would you feel that way if you were rooting for him in other respects, if you agreed with his jurisprudence, if you thought he was going to make decisions you'd like? I'm not saying any particular person or any of you couldn't answer that question. Oh, yes, I'd say it the same way. I do point out that, as everybody observed, it was almost astonishing the way that opinions about the relevance of his past conduct fell into line with people's pre-existing opinions about whether they wanted him in the first place and whether they liked what he was going to say. People on the right all thought this is quite irrelevant. People on the left thought it was very relevant. All I mean to point out is that lawyers, I think, all understand this, or they should, because it's where their conflict of interest rules come from, but it's very easy to mislead yourself about why you think a certain thing. If you're very invested in a position in an ALI debate, it's really remarkable how often people's opinions about these things track the interests of, let's say, their clients, if they're lawyers, or their personal experience. They'll say, I'm in favor of this policy, and I'm very objective about it. And you'll say, but aren't you a lawyer who spends all their time representing people who are helped by what you're saying? Yeah, but that's got nothing to do with it. I'd say that no matter what. Maybe they would. I can't say they're wrong. You can never say somebody's wrong about something like that. But I think that's part of what it would mean to be wrong in a situation. Not that your opinion's wrong, but that you might be misled, even in your own mind, about whether your interests, your underlying background rooting interests, are infecting your judgment and coloring it. And that is a very common hazard. So you're wrong in judging where your opinion comes from. Doesn't mean your opinion's wrong, but it might mean the feverishness with which you hold that opinion comes from a place you don't fully understand. And this you see a lot, I think, in life. Lawyers see it a lot. As I say, this is why conflict of interest rules try to remove lawyers from using from purporting to use objective judgment in cases where they have an underlying conflict of interest. Lawyers are all familiar with situations where they're conflicted out of a case, and they might think to themselves, I could have handled that. I could be objective about that. I know what I think. Well, the legal profession doesn't assume that. It says you might feel that way, but we doubt it. And I think one should doubt it. I think good lawyers are full of doubt about these things. So to bring it around to the ALI, I'm talking about reasons to be not so sure that you're right and reasons to be willing to defer to others and to the wisdom of the room. This is part of why I defer. Because I know, for example, that once I've written something in my draft, I get invested. Once you've spent a day writing something, you start to love it. You start to think, this really sounds good. I've thought about it. I'm sure I'm right. And somebody comes along and says, I don't think you're right. And it's amazing. You sort of resent it. You think, that's my baby. That's my kid you're making fun of. I put a lot of sweat into that thing you're criticizing. And what you have to realize, or at least what I've had to realize, is you've got to remember that investment isn't worth much. I mean, you're right or you're wrong, and the fact you spent several hours trying to say it just right doesn't really mean a thing. It means a thing to you emotionally. It doesn't mean a thing to the probability that you're actually correct. And if you've got a bunch of people in a room saying you're wrong, you might be wrong. And you've got to take that possibility more seriously than you want to. You've always got to take that possibility more seriously than you want to, and so do the others in the room. So it's a long story, but it's something I think about a lot. When you're doing a restatement, probably also when you're a judge deciding cases, I imagine, when you're a lawyer making judgments for your client, the possibility of error and the probability that you're wrong is something that always needs to be on your mind. I'm acutely aware of it at the ALI because it's pointed out to me so often. I try to be equally aware of it in my own scholarship because it's not pointed out as often, but it's got to be just as likely to be true. The nice thing about the culture of the ALI and the nice thing about a well-functioning academic culture or any law firm or courts culture, if it's a collegial court, is that everybody understands, because they've been doing it long enough, that being wrong isn't the end of the world. In fact, it's pretty likely. And so deferring to the good judgment of others who you have reason to respect and who are arguing with you in good faith is something that shouldn't make you feel bad, should make you feel good. It's a sign of psychological and lawyerly hygiene. I don't mean you defer lightly. If you believe strongly in something, of course, part of your job is to fight for that thing. But remembering that even when you're darn sure you're right, you're wrong pretty often, and that you should be conceding that with some regularity or there's a problem. If you're never admitting you're wrong, you're probably, it's like never missing an airplane flight perhaps, or never getting turned down for a date. If you're never admitting you're wrong, you're probably not admitting it often enough. And if you're never deferring to others, even when you don't think you're wrong, you're probably not deferring quite often enough, because there's an optimal amount of deference and an optimal amount of admission of error, and it ain't, whatever it is, it ain't zero. And at the ALI, it's pretty high. Most people who participate in these discussions, and all the really great ALI members, including somebody like Victor Schwartz, they say their piece, they make their point, they see how it goes. And if they lose, they accept. There's a lot of people in this room, and a lot of them know a lot more than I do. And especially, I say, as the reporter, I have that experience very often. I've deferred on many points to the wisdom of the group that I might not have shared, because there are a lot of judges in that room who've had a lot of experience with these cases. It didn't seem right to me necessarily, but it seemed very right to them. And I knew there were a lot of things they knew that I didn't. And that puts me on a different footing. It means I don't necessarily agree with every line of that restatement, but I can stand by it anyway, and it's therefore a document courts can defer to in the same way. So in closing, I suppose what I'd say is the more I did this work, the more attracted I was to the wisdom of learned hand, who everybody studies in law school, and one of the more literate judges of the 20th century, who said that as far as he was concerned, the spirit of liberty is a spirit which is not too sure that it is right. I think learned hand had it right, and that's the right way to be a lawyer. So those are my reflections, my experience as an ALI reporter, and I thought now I would invite questions any of you might have about the project, the ALI and its operations more generally, or for that matter, anything else in the world of legal education you might wish to throw at me. Yeah.
I thought that was a wonderful discussion on collective engagement and coming to a consensus in a group of any kind of group, really. What do you do when people that you're dealing with aren't given to healthy introspection?
Yeah, so the question is, what do you do if you're in one of these situations in a group and you're dealing with others who are not given to healthy introspection? That is a problem, because there are people who will get up at the microphone and they won't let go. And you'd like to think that when you're in a culture where there's a due appreciation of collective judgment and humility, that everybody, that would rub off and that people would eventually get the point. But not everybody does. I imagine on every law faculty, perhaps this one's no exception, there are people who can't let go on certain issues. I've never seen a culture of more than a couple dozen people where you didn't have some of that. So I don't know if I have anything deeply helpful to say about that problem. I think that in those cases, the best you can do is satisfy the person that you really heard them, because that helps everybody. Often if people in those cases don't get their way, what they say is, he just wouldn't listen. They just wouldn't listen to me. And it's hard to convince them, no, I really did listen. I heard every word, thought about it, took it seriously, decided not to go that way. But what I found is that most people in those cases, if you can satisfy them that you understand them, they feel better, and if they must lose, even if they don't like it, they can let go a little better. So what I'll try to do is explain it back to them. I think I understand what you're saying. You're saying this and that, and this requires significant empathy, because if you don't agree with them, giving a convincing demonstration to them that you really get what they mean is not that simple. That's part of what I think law school's about. In the first year when you're being tormented by your professors and they're trying to get you to articulate in a view that's not your intuitive view, that's part of what it's about. Can you empathetically enter into the point of view of somebody who really doesn't agree with you? I've encouraged my students to do this about good old Brett Kavanaugh. I've said, here's a good exercise for you. See if you can convincingly articulate how the situation looks to somebody who sees it exactly as you do not see it. That's not very easy for most people. Not just to say, not just to parrot, say, oh, I know what they think this. No, no, no. I mean to explain it in a way that somebody on the other side would say, wow, that is exactly how I'd put it. If you can get that far, first of all, it's helpful to you, because you might realize that person, that stubborn person actually might have a point, and that's awful, right? Capitulating to a stubborn person is a terrible feeling. But it's always possible they're right. If they're not right, then I think giving them the satisfaction of knowing that you really got it, you really understood why they think that, and what it's like for them to see it that way, it's pretty good consolation, and I think that's the best I can do for somebody in that position. Other thoughts, comments, or questions? Yeah.
How would you try to promote that kind of feeling that you say that you have at ALI, where people they have the culture already established? It seems like hopefully it'd be easier to maintain the culture than to try to change one or to create one. And what could people do to try to create that, especially for young people who are going out and starting their own law firms or
Well, I do. It's a great question because I do think about that a lot. I think that there are courts that I think are very collegial and they have a culture and they bring people in slowly who then hopefully imbibe the culture. And so if you have a pre-existing culture of collegiality and easy disagreement, it's much easier to gradually bring people in and sort of inculcate the norms of that culture. But if you're starting from scratch, that's your question. How do you create that culture? How do you build it when the culture, you aren't starting from scratch, the culture exists and it's not like that. How do you turn a culture around? That's even harder. I think, though, that a first issue is, of course, you've got to choose your people carefully. So when the ALI puts people on its council, they think hard, is this somebody who knows how to disagree without being disagreeable and how to yield in the face of thoughtful opposition? And I think that comes when we hire faculty at the University of Texas. I put a lot of premium on this. I go to my appointments committee and I say, of course we want people who write wonderful scholarship and are people who are going to be wonderful classroom teachers and care about the place. But whatever else you get, make sure you get people who know how to play well with others when it comes to agreeing and disagreeing about matters of institutional matters around the school. Try to find people at other schools who are well known for this, people who have been good associate deans and have managed conflict between their colleagues, things like that. Because people like that, they're very important to a school because they can elevate the rest of everybody else's game. They can cause others to benefit from their example, and they can, in their own right, do a better job at managing disagreement. So I think for openers, just realizing that the quality of the people you choose to partner with or associate with in your new firm, or in the firm you're thinking about joining, or the nonprofit or whatever environment you want to work in, that's a very important issue. It's not just a question of finding other attributes so the firm does the work you like. You want to be part of a culture of people who have a sense of humility and respect for each other. I may sound obvious, but I suppose is not obvious is just the weight I would put on that. I think everybody agrees they'd rather have that than not have it. What I'd say is that should be one of the highest values of any institution that's trying to do anything that's anything to do with law, maybe that has anything to do with anything else. If you're in a situation where you're already stuck in a culture that's not that way, and of course I'm now describing a great many of our legal institutions, I'm sorry to say, you have a much harder problem because you get distrust, which is a very expensive thing in life. If people don't trust each other and they assume the worst about each other, which I think describes a lot of the people in Washington attempting to carry out the work of the federal government, then everything the other side does is interpreted as a further sign of bad faith. This, to me, is part of the story of the Kavanaugh nomination. Every new piece of evidence that would come in would fortify each side's pre-existing story that the other side's basically acting in bad faith. When you're in that cycle, it's really hard to get out. I mean, usually what has to happen, I think, is one side has to make concessions and be trusting and try exposing themselves and then not be double-crossed and feel that it was reciprocated. And then what happens, and if it doesn't get reciprocated, you could spend years and years, decades, centuries, locked into cycles of escalating distrust. It's one of the hardest things, I think, in the world to undo. Yeah.
You know what I have a hard time agreeing with you about is saying that it's okay to be wrong. I think if you're in the real world and you are a litigator, you absolutely do not agree with that. Because if you are wrong, you're going to lose.
Well, we have to think about, fair point, but there are different things one can be right or wrong about. If you're representing your client in a jury trial, I don't think you want to walk in and say to the jury, look, I may be wrong. I suppose there are moments when you might say that to win over the jury with your very endearing sense of humility, but for the most part, you've got to go in there completely projecting complete conviction, and the best way to project complete conviction is to have it. So I'm quite willing to agree there are situations where, as a lawyer, you need to be sure you're right or at least act like it. But there are a couple things I would say about that. One is, even in those cases, of course it's possible you are wrong. I used to work at a law firm where I had a colleague, and I went to lunch with him and said, how do you handle it in a case where you're not on the right side? You're representing your client, and this is a litigator, and you know your client, if you were a judge, you wouldn't rule for your client. He said, that's really interesting, Ward. I guess I've been lucky. I've never had that problem. And I thought, wow, okay. I guess that's one secret to the person's success, but I thought that's very sad. Because of course you've had that problem. No lawyer is quote unquote lucky in always being in the right. Now I think it's professionally useful to believe you're right because you've got to convince others that you mean it and you've got to convince a jury. A jury's not going to believe you if they don't think you believe it. I get all that. But even apart from that, if you know that you might be wrong in the long run, I think it makes it easier to handle your losses in court and be able to move on from them the same way a doctor moves on from treating a patient who didn't make it even though they gave their best efforts. The book I've written on the philosophy of the Stoics is partly about this, that there's a right way to care about your cases, which is you're all, just like at the ALI, you're all in. You want to win, but you also know that sometimes you're going to lose, and that in the long run, sometimes you probably should, if in a well-run world, because most of us don't have the luxury of always being right. Now, there are people who might feel they do have that luxury. For example, I was discussing this at my law school, and there are people in our capital punishment clinic. They said, oh no, we have the luxury of always being right, because the only cases we argue are cases trying to get people off of death row, and we believe that nobody should be on death row. So no matter what else we're wrong about in the case, we never worry that we're on the wrong side of anything. Okay, but there are other decisions lawyers make, like how sure are you that you're right about winning? Forgetting for a minute about being right about whether your client ought to win, which is probably a useful thing to believe, 100%, even if the truth is it's more like 90% or something. What about just advising your client about whether you're going to win the case or not? Again, you want to feel, if you're going to litigate the case, you want to feel like you're going to win, but you really want to give your client accurate advice. And you might be wrong about that. So learning how to talk to your colleagues, am I going to win this case? I think I am. I feel like I've got a great winner. But then again, I've been invested in this case for months. Having somebody who says to you, you know what, it's not that hot a case. Your argument's not as good as you think it is. I know you think it's great. You're really invested in it. But having colleagues who are willing to tell you that, and then being the kind of person who can take that in, boy, I think that is being one of the most valuable skills a lawyer can have. And again, that's part of what law school, I think, is about, is teaching you to distrust your first impressions and your easy assumptions that you're right, and make you much more reflective about the possibility you might not be. And if you're giving advice to other people, you're conscious of that. But your point's well taken. There are circumstances as a lawyer when it's better to leave your doubts at the door. There are. Yeah. Sir.
So I'm interested if you followed any of the difficult time the ALI has had launching its restatement of copyright, because what you said a few minutes ago about people kind of growing hardened into their respective camps and seeing everything that happens as further support, that sort of looks like that's been playing out there, hasn't it? With so the project was announced a few years ago, and they appointed reporters, and there has been this sort of sustained period of attack from industry groups, basically saying that the whole enterprise of trying to do a restatement to something like copyright is inherently flawed, because you're just going to get professors arguing against what courts have done, and you're never going to get buy-in. And that effort seems to have really hamstrung that project from even launching. I wonder if you could talk to the reporters, what would you recommend for them?
Well, I hope you'll understand that I think I'm not going to comment in detail on other reporters in their restatements, because it is true. No, but your question is very interesting. I'll see what I can do with it without getting too detailed about particular situations, because it's true. Not every I've painted. I've tried to paint a very favorable picture of the ALI and how it operates, but that's how it operates at its best. And not every project is the ALI, perhaps, at its best. Some of them are much more contentious than mine, and some of them involve people not yielding or projects not getting off the ground or getting hamstrung for years, because people don't take the approach I've described. And you mentioned industry groups. That's what happens a lot, is that you get groups that have very strong interests, rooting interests, in how these things come out, and they get in there, and in effect, they lobby. Now, I've seen this, and I was fortunate because I didn't have a lot of this, because there weren't a lot of industry groups that saw that they had a dog in the fight that I was taking care of. I mentioned products liability was a more contentious area. That's, of course, because in those areas you do have industries that can see these decisions in the restatement are going to cost us huge sums if they don't go our way. When I'm writing about the law of interference with contract, nobody in advance sees themselves as a repeat player on one side of that or the other, so they don't come in there and lobby. The thing you have to remember about the lobbyists usually is they're in better faith than you think. Then again, good faith isn't all it's cracked up to be. I mean, somebody shows up from an industry and they get heated, they turn red in the face at the microphone talking about what an outrage this is. And you say, look, take it easy. You understand, you're representing a party here that has a stake in this. And they'll say, that's not why I'm saying this. You say, no, look, I know you don't think it's why you're saying it, but I think you have to credit folks like that with good faith in that they could pass a polygraph saying, that's not why I'm here. But it is why they're there. And they'd say, look, it's not that I'm here because of that, it's that I have experience. I spent 20 years representing this party. I know how they get screwed by courts. And so it's not that I'm trying to win because of them, it's that I'm telling you what I know. And this is what many lawyers would say. Defense lawyers who repeatedly litigate against plaintiff suits for defective products, they'll often suggest to you that they have a pretty low opinion of a lot of plaintiffs' lawyers. But it's not because they're on the defense side, it's because of what they've seen. And the plaintiffs' lawyers tell them the same thing. They have a low opinion of a lot of defense lawyers. It's not because they spend all their time representing plaintiffs, it's because of what they've seen. But what you see is, of course, filtered through the role you have in the process. And it's very hard for anybody to let go of that role. So I do think that in those cases, there's no magic to it. I think that the best thing a reporter can do is try to spend a lot of time with those interest groups and satisfy them they're fully understood. But you've also got to be able to say, look, I understand exactly what you mean, I understand why. I hope I've convinced you. I really understand your argument. But you might lose because there's a lot of interest in this. I've got to balance them all. And you might win on some other things. And again, it comes back to, that's a way to reduce the amount of intractable disagreement. It can't be eliminated. And if somebody decides they're going to fight tooth and nail no matter what you say, you've just got a problem. And you might have a broken problem that doesn't get fixed. I mean, there are little things you can do to try to, as we all understand, use diplomacy to work your way through an impasse. But there are a lot of impasses in this world that no amount of diplomacy seems able to break through. And even the ALI has been known to have one or two of those. All we try to do is reduce the number of them and the intensity of them. But every now and then you get one, and it just won't go away. Well, we have a reception scheduled, and maybe this is a good time to stop and have that. I'll be there and look forward to the chance to chatting with any of you who informally would wish to share thoughts about this. Let me thank you for coming out and listening to me talk about the ALI, a group I'm very proud to serve. And let me say again, I hope you're all proud of your association with this school, which has a very great reputation back in Texas, where I'm from. Cheers.